Hi, my name is Garrett Green. I'm a partner with the law firm of Nichols and Green, and today I want to talk to you about reckless driving defense in Virginia and how to avoid suffering the full repercussions of what law enforcement likes to do when you drive 20 miles over the posted, or anything above 80, or if it's in a 70-mile-an-hour zone, anything above 85. I'm going to focus today on cases where jail time and loss of license are generally not sought, but where if you're not careful and if you don't pay attention to your defense, you're going to wind up with a permanent criminal conviction. This, after all, is a crime in the same category as a Class 1 misdemeanor as drunk driving, assault and battery, petty larceny, certain levels of drug possession. It's crazy, but that's what Virginia has done now. It's not just a speeding ticket, it's not an infraction. If you've been charged with reckless driving in Virginia, pay attention and take notes as to what you need to do to avoid that permanent criminal conviction. Some people have extreme concerns. They may hold a commercial driver's license. They may have security clearance concerns. They may have immigration concerns. And the more you do, the better I can do with it. At a minimum, it's helpful to have you write up what happened, dialogue with the officer, what road conditions were like. We want to argue it's raw speed. We want to have no aggravating factors whatsoever. And naturally, prosecutors and judges will be seeking to elicit testimony from the officer as to anything at all to make it stick, whether there was tailgating, weaving, changing lanes without signaling, cell phone use, alcohol in the breath, a minor child in the car, perhaps slow to pull over. Anything they can think of to make the charge stick. So at that stage, it's not pitching or selling to me. This is for my eyes only. You're actually alerting me to anything that might get used against you, so I'm not sandbagged or caught off guard at trial. It is also nice to have a brief biographical statement, and it's a step that many attorneys skip. They reason that it really has nothing to do with the case, and why would you bother a potential client telling you about them personally? Well, I've been doing this a while now. I consistently get better results when I know about my clients personally, and I can talk about your hobbies, your interests, your employment, family situation, where you were headed that day. Just talking points. To the officer, to the judge, to a prosecutor, it's just another case. But it means a lot to you and me, and it's important that I humanize you and point out you're a real person with concerns and one who frankly does not want to have to spend the rest of their life answering affirmatively that they've been convicted of a crime. It's extremely wise to knock out an online driver improvement course. There are at least two that I think would be advisable. At a minimum, do one, depending on what your record is. They're both done online. An 8-hour online driver improvement course that, if you happen to be Virginia licensed, is worth up to 5 positive points on your record. And then a 4-hour aggressive driving course, which doesn't provide any points, but is, again, a very pretty piece of paper to hand up to the court. If your car is older or has very high miles on it, there's a possibility that your speedometer does not read perfectly accurately. And while it won't make this whole thing go away, it is helpful to say that even if you were going in the mid-80s, you only thought you were going in the high 70s. If, for example, your vehicle is off by a few miles at 55, well, when you get up to the 80s perhaps, that error is likely to be magnified. So if it's off by 2 or 3 miles at 55, it could be off by double that at higher speeds. So if it's off in your favor, we want you to get a calibration report. There's a chance that if it's off the wrong way. And then clearly I don't want to go to court and say, well, Judge, he thought he was going nearly 90, but it was only in the low 80s. So if it's off the wrong way, there's no need to disclose any of that. It's just broken. You just get a mechanic to write you an invoice for what he would charge you for parts and labor to replace your defective speed sensor or whatever the mechanic wants to call it. And there's no need or cause to be conceding that it was off the wrong way to law enforcement or to the judge. You say it was broken, which is true. So if it's off in either direction, we can do something with it that'll benefit you. Many people don't understand that when that summons is presented to you, that it is not an admission of guilt. It was simply given to you as your personal promise to appear on the trial date. This is not the place to be arguing with the officer about whether or not you're guilty of reckless driving. Don't refuse to sign the summons because you don't feel you're guilty. You'll only bring yourself a whole world of trouble. I've had clients who have been arrested under these circumstances for not signing the summons. Their car impounded, they're dragged in front of a magistrate. It's a big mess. Sign the summons. You're not admitting guilt, you're just saying that you'll be there on the trial date. I hope this information gives you some idea of how you might begin to address your defense of the accusation of reckless driving. The consultations at my office, of course, are free, and I'm happy to speak with you about your case and how I can help. I hope this information was of assistance, and I look forward to hearing from you. I'm Garrett Green with Nichols & Green.